pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
President Solo,
Yes.
my constituents have phoned me and asked specifically with the recall Holloway CRW board sign if I'm in favor of her recall. Obviously, I'm not in favor of it, and I'm requesting you to find out whose sign it is that's up there on the freeway and remove the inference that the board is approving this recall, and allow those people that had that sign put up there to man up and put their own name on it. Don't infer that it's my belief that that should be done.
Okay, we'll look into that. This is a special meeting tonight. We're going to have one action item in two parts, and we'll start off with action item number 2.
Chair Singh,
Yes.
are you going to ask us to approve the agenda? Because I do have a question about it.
I guess we can.
Thank you. In the original form of the agenda, the subject of providing legal defense counsel for Commissioner Sterling in connection with the Vance Boyles bully complaint was there, and it has vanished. This arrived late in the afternoon, and so I am curious about that. And I also would just point out for the benefit of the board that both Mr. Kalani and Mr. Humberston have an actual conflict of interest in the agenda items as they appear here. And it would be inappropriate for them to participate in the discussion or to vote on either of these motions because of that absolute conflict of interest, actual conflict of interest.
I'd be curious to know what the conflict of interest is, Mr. Chairman.
Pecuniary conflict of interest, Mr. Humberston.
What pecuniary conflict of interest?
You receive compensation for being a member of this board.
As does everyone at this board.
I have.
But, excuse me, it is my opinion that the question on the table is whether in fact you and Mr. Kalani actually are members of this board. And as members of the board, unelected members of the board, you have a conflict, pecuniary conflict. Commissioner Sterling and I do not, and I don't believe Commissioner Sola does, because Commissioner Sola was appointed both sides.
May I ask what law school you went to?
Probably the same one you did, Mr. Humberston.
I never claimed to go to law school. I listen to the advice of counsel, man. And I do not presume to know whether or not you happen to have gone to law school or not. That's why I asked the question. But the bottom line,
I have never claimed or inferred, Mr. Humberston, that I have gone to law school. I have stated my opinion as Commissioner referencing the Oregon ethics laws.
you usually seem to know more about the law.
Point of order, President Sola. I mean, he's reduced it down to personalities again. He comes in and says that his brother-in-law or his sister or somebody is an attorney and advising him. Now he's critical of Commissioner Holloway because of her due diligence to do what any citizen in the state of Oregon or the United States of America has, and that's to take and research the law that we empower our elected officials to enforce.
And we're expected to know.
Well, according to the law, the quorum is 3 in this board, and according to the law,
Which
the majority, Oregon law.
Which specific ORS are you talking about?
Well, let's see. We can go with our own policies, but ORS 192.610 if only a quorum is present, a unanimous vote is required to approve a motion. The board consists of 5 members. Members must declare a conflict of interest or abstain from voting when required to do so by law, and may abstain on the basis of a conflict or other reason when allowed to do so. It's a board of 5 commissioners according to the law. Under Oregon statute 558-410, a majority shall constitute a quorum to do business, and board quorum is defined under corporate code as a vacancy on the board does not change the number of directors needed to make a quorum. The board means a majority of the number authorized by the bylaws, not a majority of actual directors. So when you had excuse me, but I have the floor. When you had your meeting, you had 2 people present, not 3. Since that time, the court has appointed 3 of us to this board, and I'll stand by what the court's appointment is, and you can do as you see fit. In the meantime, I believe we have an action item to be discussed.
I would just make the statement that the question of who's actually on the Clackamas River Water Board of Commissioners is going to be decided by the Supreme Court. 3 commissioners, including Commissioner Monroy, authorized James Huffman to represent Clackamas River Water in this matter. Commissioner Monroy would be in attendance had the Clackamas County General Counsel, Stephen Madcourt, not made it clear that the county would direct the Clackamas County Sheriff's Department to remove Mr. Monroy should he attempt to exercise his position. Mr. Humberston and Mr. Kalani are usurpers and have no legal authority to represent Clackamas River Water. Further, as I said, Mr. Humberston and Mr. Kalani have an absolute pecuniary conflict of interest and will be in violation of Oregon ethics laws if they participate in this discussion or vote on this issue. That is my opinion, having researched and my due diligence as a commissioner.
Let me answer a question. Does any court put a say on what the judge ruled?
You're talking about pro se self-representation?
Pardon?
Are you talking about pro se self-representation? I don't understand the question.
Put a stay on Judge Jones's ruling?
Not yet.
Okay, and then it stands, and they have no conflict of interest.
It's their choice. You can put on notice.
We'll proceed with action item 2.
Mr. Chairman, I move that CRW's General Counsel Phillips Law Office is authorized on behalf of CRW to retain the law firm of Harang, Long, Gary Rudnick, PC, to intervene on behalf of CRW in the mandamus proceedings and to oppose the relator's motion to stay filed before the Oregon Supreme Court by James Huffman. I further move the board waive the potential legal conflict with Clackamas County relating to an unrelated employment matter, including the 2003 PERS rate order legal issues, in which the firm of Harang, Long, Gary Rudnick, PC represents Clackamas County, as disclosed in the firm's conflict waiver and disclosure letter dated February 22nd, 2013.
Second.
Okay, motion made and second, discussion. As I remember, Clackamas County moved forward with legal action to make sure that this board was had a 5-member appointment. My question is, how come Clackamas County is not doing, looking for a lawyer to represent themselves and Clackamas River Water?
Mr. President, are you addressing that to me, sir? I have not spoken directly with Clackamas County, and they may very well intervene in this particular action, as far as I know. But I don't know that for certain. What I do know, and what I've been advised by counsel, is that Mr. Huffman, in his petition before the Supreme Court, is representing that he is the legal counsel for CRW. So that makes it a CRW issue, and as such, it is ours to defend.
Thank you. Any more discussion?
President Soa, the court has already came back and stated that only the Clackamas County is of issue in regards to this matter that will be discussed in front of the Supreme Court. And that is all. They're not asking or haven't said anything in regards to Clackamas River water. And for anyone in this room to think that they can take and frivolously start to spend on attorney fees when the Supreme Court of Oregon hasn't even addressed Clackamas River water in regards to the issue that's before them. And the ORS and ramblings of this fellow to your right doesn't have a thing to do with what the Supreme Court is going to be addressing.
Then it's your statement that Mr. Huffman has not mentioned Clackamas River water in his filings.
I didn't say that.
Okay.
Chair, so I would just point out that even in Judge Jones's order relative to the request for declaratory judgment, that Mr. Moore's motion to dismiss was mooted. It was not granted. I believe that the only legitimate party to this is Clackamas County, whose motion was granted in part and denied in part. And I would also just point out that there is a solution to this if Commissioner Sola is a bold enough man to exercise it. Relative to retaining special counsel, I had it marked here, under the revised agreement with our esteemed Dean Phillips, legal counsel to CRW, the board president may authorize retention of special counsel without requiring a vote of the board. So you do have that sole authority should you wish to exercise it. If you do, it might keep Mr. Kalani and Mr. Humberson out of the soup.
Any more discussion?
I live with the will of the chair.
I want to make it clear, excuse me, President, so I want to make it clear that Clackamas River water is not mentioned in any of the paperwork that's coming back from Salem.
Is that true?
Well, the ratepayers are not responsible or don't need to take and have legal counsel. They don't need to spend their hard-earned money on nothing. It's just that easy, sir. It's not complicated by any means.
I understand. However, I choose that if we're going to take this action, that it be by the majority of the board, which represents the ratepayers of Clackamas River water. And so we'll try to see if we can get a majority of the board to agree with this motion. And we'll discuss it.
Sir, I would request a roll call vote.
Thank you. A roll call vote's been requested. Would you please proceed?
Commissioner Hall, how do you vote? No. Commissioner Humberston?
Aye.
Commissioner Kalani?
Yes.
Commissioner Sterling?
No.
And Commissioner Soa?
Aye.
Motion passes 3-2.
We'll consider now item 3.
Mr. Chairman, I move the board secretary is authorized to sign on behalf of the CRW Board of Commissioners a declaration in support of CRW's motion to intervene in the emergency motions for stay and accompanying mandamus petitions filed in the Oregon Supreme Court, which declaration may include the following statements. The CRW Board did not authorize the emergency motions or the mandamus petitions. The CRW Board did not engage and has not engaged Mr. Huffman as CRW's counsel for any matter. And 3, the CRW Board has authorized the engagement of Harang Long Gary Rudnick, PC, to represent CRW in the subject mandamus proceedings and responses and oppositions to the motions for stay.
We've got a motion,
Second.
and motion made in second, discussion.
I have a question. What does well, it actually, that's not a question, it's simply a statement. The decision is in the hands of the Supreme Court. The Supreme Court will decide who the appropriate members of this board are. I do have a question actually, which is why, when the board president is the party authorized to sign important documents, that the board secretary would be signing in this particular case, especially because his position is one of the positions in contention.
Can you answer that question?
Yes. The document that, or the motion that you have in front of us was written by the appellate attorneys, and we have merely presented it to this board as it was presented to us.
And where's the document at?
I have it here.
Chair Solis, so,
I have,
so, Mr. Ward is, from that, do I conclude, since you've already received work product from this attorney, that that attorney has in fact already been engaged?
That is not correct.
Doing the pro bono?
Well, up to this point, until this board has authorized it, and I didn't understand the rest of your,
You don't understand pro bono?
that isn't what I said. I said the rest of your question.
It was very clear, it was, has this outside attorney been engaged to prepare the material that you have presented to the board? And you've answered no, which leads me to the assumption that it's been done on a pro bono basis, i.e. no charge. Is that clear?
That's a statement, not a question.
Okay, have it yours.
Ken, you start.
yes, I have one question. I'm not particularly concerned whether I sign it or the board president signs it.
Doesn't matter.
So I would offer a suggestion, and that is that we can change the motion to say board secretary or board president, as is deemed appropriate by attorneys. Would that be an acceptable addition? And that way,
You made it second.
Yes. Everything's fine with me.
Motion's been sought to change, and the word or board president. We have a couple of people signed up to talk about this issue. Naomi, you,
But no, I'm going to wait. So other people can go ahead and.
Barbara Camper.
No, they took it off. Okay, this process.
I'm still a little bit in shock at the fact that Patricia Holloway's personal attorney did all of this without any board action of any kind authorizing him to do it. That's really strange, and I'm glad that that's picked up in these comments. But I do want to emphasize that the first road meeting that was held by 2 commissioners was a meeting at which they took action illegally because there were not 3 people present at that meeting, and that was the legal requirement. So that first meeting was totally illegal. No actions there should ever have even been considered. All of this stuff that was thrown out.
thank you for your
Thank you.
comment. Now we have Cindy Lewis Warfin that wants to speak.
Thank you, Mr. Chair. as one of the two members of the public that was here on October 30th, to view a special meeting that had been called by two members of the board as allowed by policy. The other member being the other member of the public being, it seemed, the acting secretary for the parties calling the meeting, because that person was setting up all the visual equipment, etc. I want to state, so that there is some record of this, that the two commissioners were told at that meeting, and they have known this because they helped accede to the policy changes over the past, in Ms. Holloway's case, 5 years, or 6 years, in Mr. Sterling's case, 2 years almost, and that the policy states that, in case they hadn't read the ORSs, that the policy, are we recording again?
I have no idea, I don't know where that came from. I am recording, yes, a public meeting on a publicly displayed
Fine, Ms. Holloway,
recorder.
I
Do you have a
would
problem with that?
I have a problem with the way you have done it in the past, ma'am. Back to you, sir.
You need, well,
Back to you, sir. That they were notified that there were only two board members seated at that meeting, and that they did not have a quorum present, and that they could not go forward with the meeting. And they ignored that advice, and they ignored that statement. And that Ms. Holloway and Mr. Sterling are here tonight, I have a question about. They are sending paperwork forward to the Supreme Court to say that people are not involved in CRW, that are not legally sent forward by the county board and sworn into place. Then why are they here? If they do not believe this is a legal board, why are they here?
Thank you for your comments. Anyone else in the public?
Chair, so if I may, I would just remind the board that per board policy, two commissioners are allowed to call meetings, so there's nothing illegal whatsoever in that.
Absolutely not.
And I would also, just for the record, state that Ms. Lois Wolfman indeed was here, and she was so disruptive that the sheriff's department removed her from the meeting.
Mr. Chair, may I please answer that statement before we go on? First of all, I was not removed from the meeting. The deputy talked to me, and I stepped out of the meeting, Ms. Holloway. This is the problem that we have run into over the years. Taking the facts and twisting them to circumstances does not make them true. The question I asked was whether or not why they were here at this meeting, if this was an illegal board. Two board members have a right to call a meeting. A call a meeting was to set the meeting up. But 3 board members are necessary to allow the meeting to go forward. It is a quorum. That is what has been noticed by this board, by you yourself, sir, Chair Sala, and Ms. Holloway and Mr. Sterling should be aware of that. If they're not, I'm sorry. But I would ask Ms. Holloway, please, if she has a question about my behavior or my what I did in a gathering here on October 30th, I would be more than happy to speak with her personally about it. But I don't really think it's an issue to be brought forward here because there was no official meeting taking place. Thank you.
Johnson.
I think it's for the ratepayers. This lawsuit, another one, basically, going to the Supreme Court over what exactly? For you 3, I mean, is there some proof, are people breaking the door down that you were put in here illegally or something, or has there been any problem? No. So this is just one more thing, just keeps going on and costing us money. So I hope you 3 stay fast in this thing, because this is an endless deal. That might not even end when she's out here in the cheap seats in 2078.
Thank you for your comments.
I think I will take my time.
Naomi?
I just, Naomi Anger, ratepayer. I just want to say this, this has already gone to the court. We're just wasting ratepayers' money by sending it to the Supreme Court. It's a waste of taxpayers' money, it's a waste of ratepayers' money, and that's all there is to it. And I want to also say I confer with everything that Brian Johnson said as well. Thank you.
Anyone else? Any more comments on the board? You request a roll call?
Please request a roll call vote. Thank you.
Been requested to have a roll call vote. We'll proceed to that now.
Commissioner Holloway, how do you vote?
No?
Commissioner Humbertson?
Aye.
Commissioner Kalani?
Aye.
Commissioner Sterling?
No.
And Commissioner Soa?
Aye.
Motion carries 3-2.
Thank you. That concludes our agenda for tonight. Is there anyone from the public needs to testify further on any other topic? If not, meeting's adjourned.